ठीक करो यार.
Hearing item number 1.
My lord is aware about the fact of the case here, my lord. Now, the appellant has taken the plea of, my lord, at a belated stage. So yes. The burden is on him. So let him continue, my lord, and I'll reply.
My intellectual disability.
Exactly, my lord. I am fully ready with that. Let my learned senior proceed.
You seen the last order?
He wanted to give some citation.
You wanted to bring. You wanted to bring. Before you proceed, you wanted to bring. What do you call it? To file a report.
Yes.
With regard to medical definition as what is mild intellectual disability.
My lord.
Right.
Now, my lord, before handing over the same, my lord, I just wanted to go through once, at least to.
So you've not gone through the same.
No, my lord, I have.
Then?
I have, my lord, just to make some sort of submission, my lord, so that it will have a better impact and assistance, my lord.
You have to, but you already made the submissions. You said they'll have no effect.
All right, in that case, my lord, let me submit.
Yes. Once we get through that hurdle or that point, then issue, then will be moved. Yes.
That way, he is supposed to give me beforehand those preparations, so I could have also.
My lords, these written arguments are only on the limited point of insanity, my lord.
Oh, you made an argument also?
My lord. My lord, fortified by judgments, my lord. And that apart, my lord. That apart, my lord.
Yes.
My lord, in the entire IPC and CRPC, my lord, unsoundness of mind is not defined. It is not defined. But however, my lord, the definition and clarity will come from another act. This act is, my lord, the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act 1995, my lord.
Yes.
And at the moment, my lord, I have only one copy. I'll provide in due course, my lord. Now, my lord, section 2, subsection Q, it says, my lord, mental illness means any mental disorder other than mental retardation. Or, mental retardation means a condition of arrested or incomplete development of mind of a person which is especially characterized by subnormality of intelligence. So therefore, my lord, this won't come under the definition of insanity. And that apart, my lord, this is further fortified by the fact that, my lord, the judgments I have cited, my lord, during the trial as well as during the examination under 313 of the accused, my lord, how is his behavior and reaction, my lord?
That's important. That is important.
But here, my lord, he has been very meticulous, saying that he has shown remorse, my lord. That I did. Yes, I have done a bad thing.
Aware of his.
Exactly, my lord. So that is that.
Then I think better, Mr. Mahanta, then since you start.
No, what he said, that is not correct.
No, that means yes, he's given authority. Let him keep his arguments to reply.
Actually, what he's saying about the 2017, the act is there.
Now only you got reports that he was suffering from.
That is after this,
and
after the conviction.
For a
medical. On the basis of the medical send, that's why I'm just submitting that. Because that is not my plea. That is not my plea. Since it was subsequently developed from the jail, that's why I have submitted that. And those decisions we have submitted with regard to insanity, I know about that insanity. So, with regard to a mild intellectual disability, whether it is an unsoundness of mind or not.
Yes.
That has to be looked into.
No, whether mild intellectual disability, my understanding is that at that point of time when the trial was going on, whether this mild intellectual disability, would have resulted in, him not being in that, the
Yes.
fair trial.
That is one important aspect of the matter.
By his disability. But
So-
if that has not caused the prejudice, then,
I agree.
and if he's in sound mind to his fit to face trial, we will hear the matter on merit straight away.
No, from the circumstances, why the MDC took him. When he came from cultivation, MDC asked him to come along with him to his house. He brought him to his village, Juai, from Sangpung. He brought him there, kept him whole night, asked him to sleep with his son. Next morning, after giving him breakfast, dinner, tea, took him to the police station. He told the police that I have brought him, he murdered 2 persons, do whatever you like to do. But the evidence of the MDC was never recorded, nor he is being cited as a witness. Maybe the MDC thought the circumstances which can be evolved, presume your lordship, that this man might be having some insanity. So I can trap him, let him, instead of he get a better treatment this side.
Those are presumptions, my lord. Those are
presumptions.
not part of the
when
not
we
part
look
of
at-
the
we look at
evidence.
matter, the meat of the matter.
That not part
Right
of
now,
this
only
is right.
thing
It's
whether-
not part of the evidence. I agree that. Miss Judge, I'm thinking after getting the report, this report only recently it came. Earlier, I don't have any idea about that.
My lord, I've been very absolutely correct. My lord, there are difference between medical insanity and legal
is known-
insanity,
that
my
is
lord.
well known to
No.
Medical
Let me
and
come
legal
to-
insanity, I also know
Let me
everyone knows
complete,
that.
my lord.
That's
Medical insanity, a person may be medically, my lord, insane, my lord. It might be occasional, relapsing, or childhood, my lord. But legal insanity means at that point of time of the act, whether he was suffering from insanity. That is the difference, my lord. And these judgments will explain everything, my lord.
that insanity, as your lordship also know, after committing a crime, he may be insane. Thereafter, if he hide that instrument of the crime or the article exhibit of the crime, then he knows what he did. All those things are there. Several category of judgment there. I
Let
can
reply
do
be
that.
filed, my lord, then thereafter we'll go for.
No, are you ready to argue on this mild intellectual disability today?
No, that part since he was saying, so I had just
No, he's
said,
brought it up because then since the issue has been raised by the appellant side, so that is what. So I think it's better we hear you first that how he had been impaired in the entire trial. That's the only thing.
no, in the entry trial, if it is proved that by the medical, this mild intellectual disability
That plea was never taken. my lord.
Then we'll to hear on merit straight away. Then
will hear on merit.
then we can start this.
Yeah, we'll hear on merit.
We will examine this also. It's not that we are casting it aside.
Yes. No, that developed just because of your lordship, the report from that.
No, because you had raised it. So
I have
we
said
asked for a
that
report,
from the jail authority, they told that he is in
psychiatric
Mimhans.
assessment, whether he's
Yes.
That's it.
Anyway, I'm obliged for that. So, your lordship at page 1.
I would not say.
Lordship got it. Let me start with page 2, your lordship. Date of occurrence, your lordship, 14/5/1992. Time not noted. Page 2, your lordship.
Yes.
Then he was brought on 15/5/92, 2:30 p.m. That was said. Then date of dispatch from police station. This is very important. 21/5/1992 at 10 a.m.
No, one second, Mr.
Yes,
Now, date of our occurrence 14/5/92 time the notice.
92.
When
Then
5/92 means what?
his arrest. That's where I got it from. Here it is not readable. I got it from page 4. Your lordship will see. Date of arrest.
Okay.
Page 4. Roman 13. That is date of arrest 15/5/92.
Yes.
15/5/92. So from 15/5/92, Your Lordship, he was produced on 21/5/92 in the court. In a cognizable offence like double murder case, he was kept without production from 15/5/92 to 21/5/92.
Occurrence was 14.
14.
Okay.
15/5/92. He was never produced in the court, arrested. 16, he was never produced in the court. 17, 18, 19. Then on 21st, he was produced in the court. There's a very big lapse here.
21st.
Then Your Lordship will come to page 7.
Yes.
This is a final form of the charge sheet, Your Lordship. On top, Your Lordship, FIR number 69/5 of 92, dated 25/92. That means on 15, no FIR. On 25/92, a FIR was there.
Arrested since 15.
15. So for 5 days, there is no FIR.
Where's the FIR?
FIR, Your Lordship will come to the page 15. Your Lordship will see the extract copy of the UIPS case number.
Extra.
15. That is handwritten. I give a type copy, Your Lordship, page 16. Extract copy of UIPS GD entry number 500
This is
dated.
not the FIR.
This is a GD number,
Where's the FIR?
not the FIR. There is no FIR. This is the problem, Your Lordship. We'll see this. Accused produced to lock up a note. Sri Wanbet Sulet, MDC of Champung constituency, appeared at the PS and produced the following accused person and reported that the accused person committed a double murder on the night of 14/5/1992 at so-and-so Champung. The accused was kept for interrogation in connection with murder case and kept at a police lockup for safe custody after bodily search. A Doldimaja so-and-so was flashed to OC Reliang outpost for necessary action, and MTO has been informed to provide vehicle for the same. This was on 15/5/92. This is the
Keep it
GD.
down. Yes. Yes, continue.
This is the GD entry, Your Lordship.
Yes. Yes.
Then thereafter, Your Lordship will come. There is no FIR, Your Lordship. Then let me see. PW1, let me come to straight PW because there is no FIR, Your Lordship. Page 34. I know the accused Sri Edwin Sungao, who is present in the court today. On the day of incident, but I do not remember the date, month, or year. My late husband Sri so-and-so Raban, while returning from the Pine Groves, the accused person stabbed my late husband with a dowel on his head. I was in my compound. I saw that the accused firstly stabbed my husband and thereafter stabbed my mother, Srimati so-and-so Sungao, in the neck. Thereafter, accused dragged body of my late husband to his house, and my late mother asked the accused, "Why you kill my husband?" The accused then stabbed my mother on the neck at my compound. Both the victim died on the spot, and the accused dragged both the bodies and put them together. Thereafter, the accused fled from the scene. During the day of the incident, 3 of us were present: myself, Srimati Samju Sungao, and Srimati Yorita Sungao. I do not know who informed the police, but on the same day the police came in the evening and took the dead bodies. That's all I know. Thereafter they cross. My husband was a daily wage laborer. The accused is my uncle or my late husband. The place of occurrence is about 15.
So he's the accused is uncle, means uncle he killed.
That's what they say.
Patricide, yes. Okay. Yes.
Place of occurrence 10-15 meters approximately from my house. At the time of this, I was at my veranda and there were 3 other adults were present. They were also standing with me at the veranda. I did not raise any alarm on seeing the incident as I was scared. There were also residential houses near my residence. The incident happened at about 4 p.m. 4 p.m. There were also other neighbors, but none of them came out. As I was shocked, therefore, I was not able to convey my information to the police. I had not informed about this incident to the co-villagers or even the headman. No one else except the 3 of us came and saw the dead bodies lying in my compound. It was not a fact that my late husband had any grudge with the accused during his lifetime. It is a fact that I saw the accused dragging my late husband from the village footpath to my compound. It is a fact that at the time when the accused stabbed my mother, I was standing nearby my deceased mother, and on seeing the incident, I ran to the place where my husband was lying to find out if he is still alive. At the time, Srimati Samjur Sungo and Srimati Yorita Sungo were standing there. Srimati Yorita Sungo was standing in the veranda carrying baby, and so-and-so was just standing. Srimati Samjur Sungo is my elder sister, and so-and-so is my niece, aged about 15-16 years at the time. It is a fact that even Srimati so-and-so and so-and-so did not raise any alarm at the point of time when the incident took place. I remember that my husband was stabbed by accused on his head and my mother was cut at the back of her neck. The police arrived in my residence at 7 p.m. It is a fact that the accused had used the dowry to commit the offence. It is not a fact that I have not seen the incident with my own eyes and my story of the incident is fabricated. This all with regard to the cross. Then next comes PW2.
Yes.
PW2 say, I know the case as the mother deceased late so-and-so was my mother. And late so-and-so is the husband of my sister Srimati so-and-so, husband of the PW1. During the time of the incident, I was also married and myself and my sister so-and-so along with our husband were staying together with our mother in their house. I do not remember the date, month, year of the incident since it had happened decades back. My brother Hambi Sungo died some time back. On the day of the incident at 3 p.m., I was grinding paddy in the compound of the house while my mother was also nearby sitting. The accused person, Edwin Sungo, is from the same clan which she belonged. While the husband of my sister's so-and-so Raban was somewhere outside nearby the house, while I was grinding paddy in the compound, the accused came with a dao kawai to our compound and straight away chopped Lo Raban with a dao, and thereafter accused came and chopped my mother, and then the accused pulled both the dead bodies and kept them together, and then the accused left the place. I did not do anything, only as me and PW1 were present. After some time the villagers came, police also came to the house and removed the dead bodies to Civil Hospital Joy. I have also signed on the inquest report, Exhibit 1 and Exhibit 2, Exhibit so-and-so, my signature, now cross. On the day of the incident, my husband Hambi Niam was also present at the house and he also saw the incident. But my husband did not raise any alarm as he was scared. There are other houses of the neighbor near our house, late so-and-so Raban, was also was doing the job of grazing cattle, but on the day of the incident, he did not go for grazing cattle as he was having some walk in the house. It's a fact that none of the neighbor saw the incident. The person who saw the incident, only me and PW1, my husband, did not see the incident though he was in the house. At the time of the incident, when the accused chopped disease Raban, the disease was outside the compound of the house. Low Raban was chopped on the head while my mother was hit by on the back of the neck. My mother, so-and-so, Hambi Sungok, came to the house after the disease was killed and he informed the police. During the time of the incident, I had 4 children and they were all minor. Now the age of my eldest daughter is 30 years. I do not know why the accused killed my mother and Loraban. Prior to the incident, accused never visit nor house, though we know him being the same clan. I have my thumb impression exhibit so-and-so on the same day of the incident. So PW 1 and 2, their deposition or their 161 was never there, never recorded. This is very important. Now PW3, page 38. That is cross decline here, actually what they say. I retired from service as Inspector of Police in 1998 after having served in the police for 32 years. In 1992, I was posted in Juai, Jayantia Hills district as officer in charge of Juai PS. On May 15 May 1991, Mr. Wanwei Sule, the then MDC of the Sampung Colliery, along with others, came to the PS and produced one, Edwin Sunga, and reported that the accused have been committed a double murder in the night of so-and-so at so-and-so. On the information, I made GD entry by entry number 500 dated 15/5. The accused was kept in the lockup and I endorsed the investigation to the in-charge Raliang outpost SI GS Walang, who has since disease. Exhibit 3 is the GD entry, that GD entry is there. Therefore, it was declined. Now, PW4 is very important, Your Lordship. I joined the service on 1st May 1970 as ASI and retired in December 2015 as Sub-Inspector. I was posted in 1994 till 1995 as officer in charge. The incident case was investigated by SI GS Walang, who has since expired. The date of occurrence was in the year May 1992. After the investigation is completed by SI GS Walang, the charge sheet was submitted and I have forwarded it to the court as the then officer in charge. As per the investigation of GS, the facts of the case is that on 14/5/92 during the night time, 2 persons, namely so-and-so and so-and-so and Shivati so-and-so and so-and-so were murdered by the accused person, Sri Edwin Sungo, in their house by means of a dowry and left the dead bodies there. The IO held the inquest and dispatched the bodies to Juai Civil Hospital for post-mortem. IO has also examined 3 witnesses. He said so. IO has examined 3 witnesses. And on completion of the charge sheet submitted, the charge sheet under section 302 IPC against the accused person. I have simply forwarded a charge sheet in this case. Cross. From the record, it is seen that there was no seizure. Was seized by IO in the case. This is he forwarded the charge sheet simply. Now comes the doctor, PW5. We are not cross-examining, declined, injuries are admitted, those. Now, PW6. PW6 is very important. Here is the IO. I joined service in 1990 as sub-inspector of police and posted at Joy, Eastwell, Jantia Hills district since the year 1992. I am the IO of the case endorsed to me by the then OC of Joy PS, K. Khongla. Inspector K. Khongla had entered GTNT number 500 dated 15/5/92, and on the basis of GTNT, I was endorsed to investigate the matter. On being endorsed with the investigation, I proceeded on 16/5/1992 night to the PO. This is important, not 15 or not 14. On 16/5/1992 to the PO, which is at so-and-so at Changpung. In the compound of the murder disease, Lakwa Songo, there were 2 dead bodies, one of late Simoti.
Dead bodies are lying for 2 nights.
2 nights. That is the surprising part. It's a cognizable case and dead bodies are lying 2 nights. There were 2 dead bodies of Simoti so-and-so and Simoti Rabon in the compound. I have held inquiries on both the dead bodies, which were identified by the family members of the deceased. Their bodies were lying on the ground, covered with a shawl. Exhibit 1 and Exhibit 2 are the inquest report prepared by me, and Exhibit 1 by 1, 2 by 2 are my signature. The dead bodies were sent for post-mortem to Civil Hospital Joy, and I returned back to the PS, and the next day I was transferred to headquarters at Ceylon. I have not examined any witness in this case. I am here. He has not examined any witness in this case, and the Pedal 3 said he simply followed the charge sheet. So where from these ghost witnesses came? He has not examined any witnesses. So it's a serious prejudice caused to the accused.
Yes.
Then the cross.
But the date, he could have made a mistake, or no?
No, inquest is 16/5. I'll show
What's
you.
in a cross?
I'll show you. Let me go to cross. The date of occurrence was 14/5/1992, and the incident took place at the PO. When I proceeded to the PO on 16/5/1982, the dead bodies were still lying in the compound. The dead bodies were sent for the post-mortem on 16/5/1982 night only. I have noticed cut injuries on both the heads of the deceased. It is a fact that I have not reflected the cut injuries in the inquest report prepared by me in respect of Lakma Songo. So that's all. These are the 6 witnesses examined. Now let me come to the inquest, if your Lordship permits me. At page 11, the IO prepared the inquest. Page 11 handwritten, your Lordship will see. And at the bottom of the page, 16/5/92, he prepared at 16/5/92. This is the original photocopy. 16/5/92.
Today also corroborates that 16/5 inquest report.
92. And the type copy I have written next page, 16/5/92. Even on top also he wrote, now I JS so-and-so Reliang outpost, today the 16/5/92 whole inquest. So type copy is there, next page your Lordship can see. Now I SI GS Walang of Reliang outpost, today the 16/5/92 whole inquest over the dead body of Srimati Lakma Sungo, aged about 70 years, identified by so-and-so, so-and-so. The dead body was lying on the ground facing the north, so-and-so. It was lying on the ground. And he signed below 16/5, and these are the witnesses.
Lying on the ground, that is a given. Only the date, everything.
Date. Then next also same week, another body inquest. Page 13 and page 14. 16/5.
What is 16/5?
16/5. So, and thereafter he was transferred to Ceylon. Transferred to Ceylon.
GNT was made on 14/5.
Yes.
Correct.
14/5. At 4 p.m.
14/5 that this one bench someone who
Yes,
brought
yes.
this, MBC brought this.
He brought on 15/5. On 15/5 he brought.
Until 14.5. Yes, okay. Arrest on 15.5.
15/5.
And bodies, and they went to PU on 16.5.
16/5. And postmortem in the night on 16/5.
Okay.
Then 16/5 that corroborates the postmortem also. He said postmortem in the night. Now, the illegality committed, Your Lordship, in the entire judgment is, if Your Lordship is pleased to note few pages of the judgment, the entire judgment based on a case diary. This is the surprising part, that has to be gone. Entire case is based on a case diary. Judgment is based on a case diary. If Your Lordship see the provision of 172, what the case diary can be used for, Your Lordship. If for a moment, if Your Lordship see section 172, subsection 2, 172 subsection 2, Your Lordship. CRPC. May I read, Lordship? 172 subsection 2, Your Lordship.
Yes.
Any criminal court may send for the police diaries of a case under inquiry or trial in such court and may use such diaries not as evidence in the case. This is the most important. But to aid to it in such inquiry or trial. But see, judgment is using as evidence. On that basis, the whole judgment has to be set aside. Supreme Court decisions are there also. Now, to that effect, Your Lordship, the judgment, whatever reasoning given, all those, before I come into that, the use of case diary, page 81, if Your Lordship is pleased to see page 81. In the paper book, page 81.
Yes. Para.
Middle portion, second, third paragraph.
Though not exhibited.
Though not exhibited by the prosecution, it is seen in the case diary. It is seen in the case diary that PW4 had drawn a rough map of the PO. Perusal of the same indicated that the PO is located to the east of a telephone main post, while there is a road to the south of the PO. PW4 did not indicate if there is any house near the PO. I have read the PW4. He had never indicated or exhibited anything about the map. These are seriously prejudging the accused. Now next, PW1 in her deposition did not spell out the motive of the murder of DW1 and D1 and D2, but it is seen that during investigation by PW4, PW1 has stated that the murder had happened due to family affairs. Where from she got it? No evidence to that effect. No evidence. Then let us come to page 89, if Your Lordship is pleased to take to page 89 of the judgment. Let me first read paragraph 53 of the judgment. On perusal of Exhibit 1 and Exhibit 2, 53 para, inquest report of the dead body of D1, D2, it is seen that both PW1 has signed on it. PW2 has put her RTI, including the LTI of Hamboy Sungo, who have expired, on 16/5/92, which is after 2 days of the incident, seen that PW6 IO has stated in his chief that on being endorsed with his investigation, I proceeded on 16/5/92 night time to the PO, which is at so-and-so Sampung in the compound of the murder disease so-and-so. There were 2 bodies, one of so-and-so and 3 so-and-so in the compound. I have held inquest on both the dead bodies, which were identified the family members of the deceased. Thus, the inquest was held on 16/5/92. 54. On the issue of why PW1, PW2 did not inform the incident to anyone in the village or neighbors or their relatives, it is seen that PW1 was scared, as can be seen from the case diary. This is very important.
Yeah.
PW4 has noted that PW1, 2 and Hamboy expired has stated that they were threatened by the accused if they report the matter to the police, hence they did not file the FIR. Where from this evidence has emerged to the learned trial court judge? Who has stated this?
Yes.
54. Then let me come to page 92, Your Lordship. Paragraph 62. Perusal of the case diary of the case shows that investigation was initiated by PW6 on 16/5/92 till 25/92, after which he was transferred to Shillong and he handed over the CD and other case document to OC Joy PS. From 24/5/92 onwards, the investigation was carried out by PW4, after which he examined PW1, 2, Hamboy so-and-so and received a post-mortem report so-and-so, so-and-so. Inquest report shows that the inquest was carried so-and-so. So these are from the case diary, not from the evidence. So the inquest was carried on by, thus the statement PW4, when stated after the investigation is completed, SIG was charge sheet was submitted. I have forwarded it to the court as a then officer instance, is not completely correct. From the case diary, she is analyzing which is correct, which is incorrect. Then thereafter again, Your Lordship can come. In fact, as evident from the above, the examination of the witnesses, collection of PM reports, drew the sketch map of the PO and submitting of the charge sheet was done by PW4. That in the instance case, it was alleged that the accused had used a doubt to attack D1, D2 was evident from the deposition of PW1. But there was no seizure made.
You mean the weapon, they will not seize?
No, nothing says. Nothing says. Next, Your Lordship will come to page 97. Paragraph 70, the last line, I'll just come. He returned back to PS on 16th that day, Your Lordship. The next day, he was transferred to the headquarters at Shillong. He did not examine any witness.
Where did he come?
Paragraph 70, the last 2 lines. 97 page.
Yes.
Very important.
This program, you see the date of instance also. To review also heroes or contents also. Here have an yes. Okay.
Next, Your Lordship, page 98. Paragraph 72, Your Lordship. From the evidence of PW4, PW6 and the case diary, evidence of the case diary, It is seen that PW6 was endorsed to investigate the case and he visited the PO, held the inquest over the dead bodies D1, D2 and sent the bodies to Joy Civil Hospital for conducting the post-mortem. On his transfer to Shillong headquarters, the case was then investigated by PW4, who received the post-mortem report, examined the witnesses, drew the sketch map of PO and submitted a charge sheet. No, PW say he never investigated. PW4 said, I didn't investigate. I simply followed this charge sheet. Earlier said that no witness were examined by the actual IO. Now, page 99, if your lordship comes. Page 99, para 73, sub-para 2. After the investigation is completed by late SIGS Walang, the charge sheet was submitted by him to the court. It is seen that PW4 received the post-mortem report, examined the witnesses, drew the sketch map of PO and submitted a charge sheet. Where from she got this? Entire judgment, your lordship, is based on a case diary. That cannot stand in the eye of law. And those, whatever reasoning given or the citation or just simply a copy of the Supreme Court decision, there's that. There's nothing. So my respectful submission that no case has been made up for conviction of this case, although if he is involved, not only conviction, he should be hanged to death. These are such a serious crime. But the investigation is charged and the learned court has relied on the case diary. No conviction can sustain your lordship. I didn't read, I just make it brief submission, your lordship, because not to waste your...
Any authorities?
Authorities, yes. Which you got to case diary. Yes, yes, it is there.
Not done, huh?
Flag A, para 13, your lordship. This is 2001, volume 7, SSC 148. Para 13 and 14, you'll see.
Para, page 1.
No, para 13 and 14.
Of Mahabir.
Yes, Mahavir Singh. Para 13, if the public prosecutor failed to get the contradiction explained as permitted by the last limb of the provisional section 162, subsection 1 of the Code, it is permissible for the court to invoke the powers under section 172 of the Code for explaining such contradiction. For that purpose, we may examine the scope of 172, the section deals. Then thereafter, your lordship, 172 has been stated. Indian evidence. Then 14. A reading of the said subsection makes the position clear that the discretion given to the court to use such diaries is only for aiding the court to decide on a point. It is made abundantly clear in subsection 2 itself that the court is forbidden from using the entries of such diaries as evidence. What cannot be used as an evidence against the accused cannot be used in any other manner against him.
Yes.
So the next flag B also, your lordship will see, para 27 to 30, your lordship. That decision is Muhammad Ankush and others, 2010, volume 1, SCC 94.
Para
Para
27.
27 to 30, they have discussed regarding
yeah,
this
on
case
diary,
diary.
you've got only 2 judgments.
That's sufficient. Because everything has been discussed there.
We have to examine the tenor of the judgment, whether only reliance placed on case diary only.
Case diary.
Yeah. Yes.
I think that's all with regard to marriage. And with regard to the insanity part, those, although it's a very nice to do the research here, I also done, but I'm not taking that plea because
Okay, but then, but in all fairness,
since it has came
we
out,
had to embark upon that inquiry.
Yes.
We should not
and
be,
accurate.
you know.
No, due to the jail authority informing the family member, therefore.
Yes, Mr. Guru.
I know I am deeply authorized for accommodation.
You have any authority, Mr. Manta, on
Yes.
the mother weapon not being seized and not being
Not for
exhibited?
produce.
I have. I have.
What you mean?
I have.
Tell,
It's not corpus decendi. Yes.
and is a
How long
trial
will it
is
take,
that
Mr. Guru?
92 case, your lordship, it has started.
But now he's been on bail since when?
He'll be about 70 up, I think. Huh? Yes,
He's how old?
more than 70, I think now.
64.
64, no, I think more. It will be more, I can find out.
Okay. How long will it take, Mr. Guru?
My lord,
How long will you take?
maybe 1 hour, my lord.
Because actually we want to have this one more date, we'll close it and reserve for
We'll
judgment.
have it in next day, my lord.
In fact, I want to, therefore, shortcut, I could have read the whole things.
No.
Just to the point I want to come.
A very good concept. You hit just on the
I
point.
precisely as just to the point.
Yes.
Because unnecessary thing, I don't want to waste your or lordship time.
On
Because
the
even I have seen your voluminous cases. And so many cases are there for the singulars.
So anyway, we'll have it. Bench.
19.
19
12 for holiday.
or 12 is a holiday.
Which day?
12th is a holiday, my lord.
12 holiday.
19 will fix and
My
we'll,
lord.
we'll complete on that day. Please, any regional arguments also?
Yes.
But in part, list on 19th.
I'm deeply authorized for accommodation. Much.
Highly obliged.
Any mention?
Please, Lordship.
Yes, Mr. Sangma.
Lordship, I beg to mention item number 60 and 61, Your Lordship. 60 and 61, Lordship. I have informed to both the parties, to government. Here is item number 60 is appeared by GH.
60 and 61.
Yes, Lordship. They are seized for
Item 60, Your
GH.
Lordship.
Who for state? Or GCC? And 61?
61, Mr.
Objection?
No objections, Madam.
Okay. 2 weeks.
Much obliged, Lordship.
May I please, Your Lordship? Your Lordship, beg to mention item number 55 and 56, Your Lordship. Conducting counsel is out of station, Your Lordship.
You've told other side?
Yes, Your Lordship.
Yes.
No
Your
objection. No objection.
2023 matters.
Blue badge.
Awesome. What's the matter about?
They're asking for service benefits, Your Lordship.
Yeah, for in
Petitioner, Your Lordship.
which department is this?
Muda, Your Lordship.
Okay. After 2 weeks, yes.
May I please, Lordship. Lordship, I beg to mention item number 54.
It's part heard.
Part heard.
Why? Mentioning part heard matter?
Conductor counsel is not here, my lord. He's out of station.
Part heard means there's no question of adjournment.
My lord, if you can take it this week itself, he'll be here.
My Lord, I have no objections, Madam.
You should object to part heard matter. Who's going to MPSC? Your objection? Two weeks, yes.
Much
If you have
obliged.
urgency, then court will not have agency. Yes. Yes.
Lordship, I beg to mention item number 65. Let it come after 2 weeks, Lordship. I have informed the respondents.
Who's appearing?
I'm for the state, my lord. There are 3 respondents here. State, Durbar and
Bank?
municipal.
Bank? Oh no. You appearing
Durbar,
for
my
bank.
lord.
Who's appearing for?
Muda.
That's all.
3, my lord. The Durbar has not entered
Yes, the
appearance.
private respondent has
appeared.
not.
My
No.
lord.
When?
After 2 weeks, Lordship.
Yes.
Much obliged.
My Lord, I beg to mention item number 63, my Lord. Let it come after 2 weeks, my Lord. And for the respondent, private respondent.
You have no objection? You for a petitioner?
No, Your Lordship.
No urgency?
Since you have taken time, Your Lordship.
This of time it means the case of your client goes down the drain, no problem.
Let it come next week, Your Lordship.
Yes. After 1 week.
Your Lordship, I beg to mention item number 57, Your Lordship.
To the other side. Here, Mr. Changre, so?
Yes, Your Lordship.
No objection?
No objection, Your Lordship.
2 weeks. Yes.
All right. Your Lordship, I beg to mention item number 58.
On whose behalf?
Mr. Esalindo. Petitioner.
There's urgency here.
No, there's no message, nothing. 2 weeks. Gotcha.
Yes.
May it please Your Lordship, I beg to mention item number 62. The rejoinder is under preparation, Your Lordship, so I humbly seek for 3 weeks accommodation.
You for the petitioner? 1 second.
Yes, Your Lordship.
You rejoined us to file before hearing, then if the matter is for hearing, you won't be allowed to file a rejoinder. Yes. You would Miss Big Hosh.
On behalf of Big Hosh, Your Lordship.
See, last time you played that rejoinder for next day of hearing. Anyway, since just after 2 weeks, yes.
Your Lordship.
You file it, we won't record anything.
My lord, I have a small prayer for upgrading one matter, my lord, hearing matter item number 66, my lord. If can be possible, can be taken up in the first half, my lord. Because
First half of what?
It has come up for hearing, my lord. It ought to have come up for admission hearing, I think so, my lord.
No difficulty with it.
It'll be called out, don't worry. Yeah. Yes, it'll be called out, it'll reach in the first half.
Yes, my lord.
Why are you in a hurry to leave Shillong?
I will be traveling to Itanagar, my lord, today in the second half. That is the reason only.
I have no objection.
So what can we do then?
No, for upgradation, my lord. After
have part 1 first, yes. Yes.
Yes, Lordship, item of 59, Lordship. There's a joint request, Lordship. Or
No. Joint request, Lordship.
2 weeks.
2 weeks, yes.
Lordship.
Item number 1.
Yes, Lordship. Lordship, here I am challenging the impugned order passed by the CEM of JJTC, the order dated 10/12/2024. Your Lordship, what happened actually, there was an order from the court to file a separate condition of delay, and then that Ms. case has to be filed in without filing the review application or without filing the application for recalling. They have just filed the condition of delay. Now they have fixed that date for hearing. That date hearing is it is impossible to hear the matter without filing an application. How can they hear the matter when there is no application has been filed? Either it should be review petition or it has to be the recording petition. The judgment was there. It says that they let the private respondent should Lordship. That is annexure page 35, Lordship. Page 35 is relevant part of that one is page 37, para 6, my lord. Yes, Lordship. I have given the thoughtful consideration to the fact and the circumstances of the case and the reason which have been ascribed by the petitioner to explain the laches and lapse normally petition like those who would not be entertained. Yes. Those would not be entertained and would deserve no consideration. However, in the instant case, considering the situation of the petitioner, who is illiterate and interest of justice, in spite of the fact that much time has lapsed since passing of the impugned order, the writ petitioner is permitted to go before the Chief Executive Member GHDC by way of an application seeking continuation for delay and seek for recall of the order dated 12 March 2010 for the re-hearing of the appeal. The Chief Executive Member in his discretion shall examine the same on its merit and pass order thereon. It is made it clear that the impugned order herein shall not be disturbed till the proceedings are finally conducted. If it is further made it clear that this case will not serve as...
What happened after that?
Now what happened thereafter, my lord? This impugned after that sequent order was passed by this honorable court, but that is only to comply this order. That another order from the High Court is there.
Order 10/12/20.
Yes, that this is the page 56, annex 11, Lord. Page 56. This is the impugned order. Merit. At both sides in detail regarding the application for continuation of delay. 3,442. There is filing application by the appellant to record the order dated so and so, in the case number so and so, in pursuance of the Honorable High Court order dated 15/11/2023 WPC so and so. Accordingly, it is directed the court to satisfy strictly abide by the order dated 14/07/2019 by filing an appropriate application before the court and to decide the matter afresh in accordance with law. Observe, impugned order is set aside and quash. Hereby, Honorable Court is directed to file an application as allowed by the order dated 14/07/2003, which is comply thereof. In thoughtful consideration to the fact and circumstances of the case, the reason which have been ascribed by the appellant petitioner to explain the latches and lapse as of inordinate delay of 3,442 days was not deliberate because of the appellant of the massive case of 1451 Brigade A, Wakso Akeng, which belongs to Rangsa clan, rely completely on the council conducting the matter and impugn order in the interest of justice. Now, my lord, even
yes. No, it didn't file review application. Only coordination application. Where's the review application?
It was filed, my lord, but we have not placed it, my lord.
Where's the
There is
why?
no motion today, my lord.
My lord, let notice go.
Let notice go. But then if his case is that only coordination application was filed, this court said file a
Yes, coordination and
recalling of the order,
yes,
and one for condoning. So he has to take condoning first. If he can be condoned, then he'll examine the review application.
Yes.
That's all. Yes.
Because initially, my lord, both condonation of delay and for recall also was filed together. Okay. But despite lordship's order,
okay, yes,
sir,
Mr. Consultant Petitioner, I should notice Mr. SD is present, except notice on behalf of 1, 2, 3. AG Movement 4 and 5. No further notice called for. Just have to tweet for instructions.
Lordship.
In the meanwhile, further proceedings are stayed.
Yes, Lordship.
We are produced and will dispose of next day. Yes.
Item number 2.
Proceedings in so and so.
But the question of stay, my lord, they have not even filed an application, and they are not praying also.
Doesn't matter.
Because only.
No, we don't see. I think something. We don't want to complicate the matter. That's all. You want to keep a clean slate, so when the matter comes, then we decide. And if it's a correct, the recall has been filed, they'll be disposed of. Although if suppose you don't pass orders, then they decide something else, then again withdraw, you'll file fresh petition again. Then this whole thing will be dug up.
Because whether the petitioner has come with a clean hand or not, that has to be
the third time has come. Second time again they filed recall and condition 1 application. They came in for this court. Court said abide by the order 19, 5 separate applications. Now it's come again saying they filed the 1 application.
That is what I'm saying, my lord. Whether the petitioner has come with a clean hand or not, that has to be.
Let him clean hand or clean face, we don't know. Yes.
Well, we are before your lordships with a communication dated 11/4/2025. What had happened in this matter is, my lords, I have a plot of land, which is a government revenue land. Now, my lords, there was a spot inquiry held, and it was found, my lords, that 89 square meters is additional in my land. There's some wasteland, my lords. And I was directed that you make payment of a premium of 3,85,000, my lords, to regularize that land and so that it can be added onto your plot. I made the payment, my lords. That payment was made by me on 21/5/2024. Thereafter, my lords, the lease has been corrected on 23/5/2024, my lords, at Annexure 7. If I may take your lordships to, my lords, Annexure 7 at page 26. Before that, my lords, I'll just take your lordships to Annexure 5, page 23, if my lords kindly have a look at it. Well, this is a letter dated the 20th of May, issued by the Additional Deputy Commissioner of Revenue. It says, with reference to the subject cited above, I am directed to inform you that on completion of survey and inquiry, plot number 14, located at DPI compound, European Ward, Shillong, leased and under your possession is 757.63 square meters, which is more by 89.65 square meters than the area as mentioned in the lease agreement. In this regard, you are requested to deposit the requisite premium fees for additional area amounting to rupees 3,84,000 by Treasury Challan. So this was there, my lords. Thereafter, the lease has been issued to me, and I was taking lordships to the lease. My lords may kindly come to page 27.
Yes.
Down below, my lords will see the area of the land is 757.63 square meters. Now, my lords, out of the blue, suddenly, my lords, I am in receipt of this letter at Annexure 8, page 29, which says, my lords, with reference to the subject cited above, I am to inform you that the area of government vacant land measuring 89.65 square meters adjacent to plot number so-and-so, allotted to you by lease number so-and-so, dated 23rd of May 24, was allotted without receiving necessary approval from the Revenue and Disaster Management Department, Government of Meghalaya. Further, you are informed that the said government vacant land measuring so-and-so is not an excess of plot 14, but a vacant government plot duly under the custodianship of the undersigned. In this connection, you are hereby directed not to carry out any activities within the aforementioned vacant land under further orders. So after regularization, my lords, that power is not there, and that also it is an order, my lords, which is passed without hearing me.
Yes.
Your Lordship, I'll have to take instructions.
Yes, heard Mr. K. Policy Council, assisted by so-and-so, issue notice. MSZ Contempt is present except those in behalf of all respondents.
All the respondents, Your Lordship.
For stop. Next paragraph. The writ petitioner is aggrieved with letter dated 11/4/2025, whereby additional land stated to be part of his lease has been regularized and lease deed issued on
23/5/24.
24. Is submitted by the State Council that, however, by the impugned letter, the said correction is sought to be revoked by the respondents. Yes, by respondents accordingly. Until the next date, the status quo shall be maintained.
Status quo will operate against me, Melod's.
Until next date, the letter will become effective. Yes.
Obliged.
Highly obliged, Your Lordship.
Item number 3.
Lordship, I'm praying for some accommodation in this case, as the conducting counsel, Mr. Bijan Chakrabarti, due to some difficulty, he could not come today.
So, my lord, let it be on 15 then, my lord. 15th of May, 1/5.
Okay, 15th of May.
In the meantime, interim will continue, Your Lordship. Lordship, as I have one more submission to make, as per the petitioner instruction, is that if he is allowed to operate this transportation contract till for another 5 months, that is till October 25, instead of the as per the contract, instead of February 26, then the petitioner will not press upon this writ petition.
We'll take instruction.
MS agent pays for some accommodation as the arguing counsel today. Accordingly, this matter on 15th May. Stop 15 May 2025.
Obliged, ma'am.
Item number 4.
My lord, item number 4 and 5 are on the same issue, my lord. This is regarding the boundary dispute, my lord. The matter is still pending before the Supreme Court, my lord.
After 6 weeks, yes. Talking to other names.
4 and 5, my lord.
6. 6.
Please, Lordship.
Yeah.
These are the bunch of contempt matters in connection with the non-renewal of trading license. 6 to 48, Lordship. I'm instructed, Lordship, that out of the total number of petitioners, around 6 or 7 of them are yet to receive the notice to go and supply. The others have gone, or they are in the process of going today. Only issue is, Lordship, the petitioners who have already gone, gone and submitted the documents. This is the third time they are going. But what is the issue is that no, they are not getting any receipt copy or any such acknowledgement.
Dingdo, this is a new address. Government should address it. Again, they deprived of livelihood also.
Fresh
Yes, no, my lord. In fact, since 25th of November 2024, these notices were issued to all.
Thereafter, we have gone and submitted.
So even those who have not received notice, you should go and submit.
Yes.
You won't pass any orders, but then you impress upon them. We listen after 3 weeks.
The only issue is they are not issuing an acknowledgement, so they are.
Yes, listen after 3 weeks. Yes, it's a matter of 3 further orders. It has been stopped. It is submitted by Mr. SD that those petitions who submitted the applications, however, have been given acknowledgement receipts. Stop. Further, some petitioners also have not been issued notices. So that's why Mr. Dingdo London Senior Counsel appearing for the respondent has assured the court that the same will be looked into and rectified.
Obliged.
Just out of 3 weeks. Yes.
Obliged.
49.
Please, Lordship. As per my instruction, Your Lordship, this impugned order, which my learned friend has enclosed, Your Lordship, that was, they have filed it after the repetition has been filed. So, Your Lordship, I humbly pray that you may be allowed to amend just my petition only with regards to the impugned order. They have enclosed in the
Your
annexure.
choice. You can file an alternate amendment. We will
Yes,
consider
I will file the.
Mr. D. Samba praised that, submits that due to certain developments, that is a fresh order having been passed by the District Commission Coordinator.
Yes.
He praised without to file amendment application.
Yes.
Then the court consider we allow amendment or not.
Yes, Lordship.
50.
We listed as and when the amendment applications on board. Yes.
Much less, Lordship.
My lord, 50 and 67 are on the same issue. Here we have already filed our affidavit, my lord. In 50 also we have already filed. 67 also filed. My lord, 50 and item number 67, the hearing list are on the same issue, my lord.
Is hearing?
My lord, one is in hearing, one is in orders.
So we'll hear it today.
My lord, on the last occasion.
In item number 50, we have gone to record by after confirmation of service by Dusty Service. Yeah.
On whom?
On respondent number 2, that is the National Medical Commission.
You've served on them?
Yes.
Your name?
Dusty. M1 Sweat.
M1 Sweat?
Yes.
Yes. Ms. M1 Sweat service that service has since been effected upon respondent number 2. So he prays and is allowed to bring the same on record by view of service affidavit. Just after 2 weeks, yes.
67 also connected.
Then 60 is together with this. Together. 67. Yes.
51.
Loving spoon well.
Well, this order also, I think, will the same fate will follow. He's passed it alone.
Yes.
Page 60. Sixty, 61.
This under Khairim.
Yes. Khairim, the new act has come into force. Prior to that, it was 1959. Now, 59 Act, that provision is the authorization.
But Khairim there's a provision there.
There is the new act.
There are also two members.
Yes, 2 members.
So the other ones that have a provision in full executive committee as to sit.
Yes.
Yes, Mr. Nombri.
In fact, they're supposed to file the reply.
No.
What reply have you noted? Understood what senior counsel has said?
What under new act?
Have you understood? Philip Chandit?
Not, I didn't get properly.
You didn't get it. See, what has been submitted is that the impugned order, that's page 60, correct?
Yes.
Has been passed in by one member.
Yes. 1 member.
So if it's passed one member, it is incompetent. So the Khairim Act?
The
Khairim Act is the Khairim Act.
Where the provision is there.
So prior to the Khairim Act, 1959 also is there.
This was, but this is 24. But Khairim Act had come to force.
Yes.
This year only. No.
This year.
So it's effective from 11 November.
Yes. So prior to that, my lord, the Act
59 Act.
1959.
Oh, then this new Act will apply.
Yes.
Yes, at the outset,
Then
it has been advised to the court that the order impugned herein has been signed and passed by only one executive member of the executive committee of the Khasi Authority Council. Stop. Mr. T. Leonard, Senior Counsel, appearing for the District Council respondents has very fairly submitted that in this view the matter as the old Act of 1959 to amendments on 79 and the new Act which has come to force on 11th November 2024 having mandated that two or more members will be authorized to exercise power on behalf of the Executive Committee. The impugned order in question is incompetent. According to submission, without dwelling or further going to the merits, the same is set aside for want of jurisdiction. That is remanded back to the Executive Committee for consideration afresh. Yes.
Lordship.
Ordered accordingly, the expected matter shall be disposed of expeditiously. Yes.
Lordship.
$52.
This matter pertains to the correction of the job card holders, Lordship, under VEC. Lordship.
Where's the affidavit?
Lordship, affidavit is required in this matter.
Where's the affidavit? You forget affidavit, even the respondent missing. Who's appearing for respondent?
Lordship, Mr. Sincon.
How many times is taken for affidavit?
This will be the third time.
Matter.
It's a fresh matter.
No, it's only one. Please. None appears for the respondents. As it is seen that affidavit that get filed, respondents allowed 2 weeks for the time. Any urgency?
Lordship, what has happened now, Lordship, as per the instructions, Lordship? Now they have constituted a temporary committee, Lordship. Now in that committee, Lordship, the person which we had alleged that they have a bogus job card, Lordship, they have been appointed as member, Lordship.
Anyway, okay, none appears for the respondents. Stop. As Mr. ML Umpian Council expressed some urgency, this matter tomorrow. Tomorrow. Yes. It's expected that there will be some representation.
Hello.
53.
Like expected, this matter tomorrow. Yes.
Lordship, I filed an affidavit showing that immediately after the cancellation of the agreement, Lordship, they have, and I filed the representation on the same day. They have allotted work to one Sri Drolan Thongni, Lordship. It is page 5, annexure 1 of my affidavit, additional affidavit, Lordship. A type copy is at page 7, Lordship.
You see a copy, Mr. Dingdo?
Yes. In fact, I have instructions also. This also has been cancelled. Now the District Council has taken a decision to call for applications and bids. Because your Lordship will see the records.
When was elections held?
Not elections, Miller. This is for the settlement of the.
Yes, when was elections, MDC elections held?
It was held in March.
And EC constituted when?
I think soon thereafter. Because, my Lord, what is happening here, your Lordship will see the records, the writ petition. This fellow petitioner has been running this gate for the past 4 or 5 years. There were no bids, no tenders. And in fact, it was settled 2 days before the Model Code of Conduct came into.
Yes.
So we are trying to streamline, my Lord.
Yes, Mr. PD has referred to additional affidavit filed on behalf of the writ petitioner to show that on 25th April 2025, the work for collection of toll entry of goods tax on animals has been settled with a third party 160 Roland Thomni. Mr. to obtain instructions on the same.
Lordship, in the meantime, since I am in still.
No interim orders because
No interim orders,
no
my lord,
problems.
yes.
1 week.
1 week I'll file.
Just by Thursday, you please come.
I'll file my affidavit.
Yes, this matter on Thursday, as it is urgent. Yes.
Hearing 64.
Actually, 66.
66. 66. 66.
Oh, upgrade my name. So I should part 1. It's not us here. Oh, damn. We'll change the order. Yes.
Please, Your Lordship. Hello, this matter, Lordship will recall, relates to my challenge to the legality of a debarment order which has been passed by the respondent FCI, debarring me from participating in any future corporation tenders for the next 3 years. Now, I have principally challenged it on 2 grounds. One, that it was not preceded by a show cause notice, and number 2, that the penalty of debarment that has been imposed on me is highly excessive and disproportionate in comparison to the nature of the infraction. And the infraction, my lord, is non-deposit of the security deposit. The amount for that security deposit was a meager 35,000 rupees. Now, I have gone through the affidavit that has been filed by the FCI.
Yes.
So what they're saying is just 2 things, my lord. This is a summary of what they've said. One, that the petitioner was aware of the condition relating to deposit of the 5% within a stipulated time period. And because there was a default on our part, therefore we are liable for the consequences under the contract, which is termination and debarment. The second thing that they're saying is that we had made a prayer for extension of time to deposit the security deposit beyond that stipulated period of 14 working days. They say that cannot be entertained because it's not provided under the contract. So therefore that prayer was not tenable. Beyond that, what is very curious, my lords, they have neither addressed the issue relating to the question of non-issuance of the show cause notice, nor have they addressed the issue relating to the disproportionate nature of the penalty. So, my lords, in my humble submission, there is no contention in that case. That was the moot issue.
Where have they done that? This is all.
Not at all. Please have the affidavit, my lord.
Yes.
My lords, we'll see from para 4 onwards. Apologies, para 6, page 4 onwards.
Yes.
That the statements made in para 4 of the writ petition, save and except the statements borne out of record, are not true and correct, and the same are hereby denied by me. In this regard, I say that the bid validity was 90 days, that is up to 5/11/24 from the date of submission of bid, that is 7/8/24. Since the formalities of evaluation was under process, the bid validity was further extended for another 90 days up to 1/2/25, and all the bidders who participated in the bid, including the petitioner, had accepted the request in the GEM portal, and a confirmation email to the effect was received from GEM via email dated 4/11/24 and 5/11/24. Further, I state that without a bid validity extension, the bid would not have been active. Thus, it is well construed that the petitioner has not come before this court with clean hands and trying to present the inaccurate picture. On this count alone, the petition is liable to be dismissed. Then please see para 7. That the statements made in para 5 of the writ petitioner, save and except the statements borne out of record, are not true and correct, and the same are hereby denied by me. In this regard, I state that the updating the technical evaluation in GEM on 8/11/24, wherein the petitioner had technically disqualified for not depositing the AMD, the petitioner had submitted a representation appeal challenging the disqualification description, etc. So and so. And then please see the line thereafter. Accordingly, the petitioner's representation was considered that the company's BIS certification is valid and verified on the BIS website, and as per the general terms and conditions on GEM, sellers with valid BIS licenses can be exempted from furnishing EMD and accept it, and was updated in GEM portal. But thereafter, again, if your lordships just go through, nothing in relation to the principles of natural justice violation or the question of the disproportionate nature of the penalty have been addressed anywhere in the affidavit.
See, it's that means whatever actions you have done is bona fide.
My lord.
There's no question of any malified.
There was no malified. And my lords, what is most important, if your lords will just have my rejoinder for a moment.
Yes, that's the only thing.
Yes, my
if you're, whether. Yes.
I'll just point out two things. There was a bona fide misunderstanding as far as I'm concerned with regard to the 14 working days. Please have page 5 of my rejoinder.
Yes.
So there is a confusion with regard to central government holidays, gazette holidays, state holidays. So your lordships will find the list of all the holidays recognized by the center as well as the state. So FCI does not function on Saturdays. We've taken instructions. So Saturdays and Sundays have to be excluded. Even if we don't go into this issue, my lords will see another aspect at page 10 of my rejoinder. There is no motivation for me to not deposit the security deposit, which is for a meager amount of 35,000. My lords will find there are 19 completed contracts with FCI alone. And this has been satisfactorily completed without any complaints from FCI. So there was no malice involved in it.
What was the infraction?
My lord.
Number one, you said?
Please have the termination notice, my lord. As per the additional terms of the contract.
Where's the termination notice?
My lord. There are two termination notices here, my lord. Please have the writ petition, page 40. 1
second. 40. Yes.
If lordships, this is an email from the AGM QC NEF dated 4th of February 2025. Sir, kindly refer to the trailing mail. In this regard, competent authority has not accepted your request for extension for making the SD payment. Now, as per clause mentioned in the ATC of bid document, which states in case of failure of bidder to deposit the SD mentioned above within 7 working days, further extension of 7 working days can be given by FCI subject to levy of penalty at 1% of SD. If the bidders fail to deposit the SD by the cessation of extended period also, it shall be lawful for the FCI to terminate the contract, treating it as a breach of contract and to award the contract at the risk and cost of such bidder. Accordingly, the contract is terminated. So it was for non-deposit of the SD amount within that stipulated period of 14 days.
Yes.
And may I just point out, lordships, at page 39, there is an email towards the bottom. This is an email dated 15th of January. They claim that this is outside the period of 14 working days. We had written to them seeking an extension. It reads, Dear Sir, season's greetings from Tandan. Apologies for the delayed response. We would humbly request your honours to kindly give us an extension for making the SD payment. Due to long vacations of Christmas and New Year and Sangranti, we could not make the said payment. Hence, kindly consider the same at the earliest. Further, kindly be informed that your order of 62 pieces of CLTF covers will be ready for pre-delivery inspection by 18 January 25. Kindly depute the PDI team for the same. Few details are mentioned below in this regard. So we had made a request on the 15th saying that we would need some form of extension for deposit of the SD. And they responded on the 4th of February by saying that it would be, the contract was terminated. Then my lords will find there is another order at page 42. And in the meantime, my lords, they had also floated a second bid on 4th of February 25, which they withdrew. Thereafter, they issued a second termination order.
No, 42 is dated.
The date is on the next page, just below the digital signature, 26th of February 25.
6 to 25, yes.
My lord. At page 42, please have para 3.
Yes.
Whereas, as per GEM tender clause number 22 of ATC, Tandhan Polyplast Limited was required to deposit 35,808 as security depositing within 7 working days from the date of issue of contract order, that is by 3/1/25. The said 7 working days within which the tenderer had to make the payment of rupees so and so as security deposit expired on 3/1/25. The tenderer failed to deposit the SD amount even when the tenderer was well aware of the timelines. Further, as per clause 22 of ATC, in case of failure of bidder to deposit the SD mentioned above within 7 working days, further extension of 7 working days can be given by FCI subject to levy of penalty at 1% of FD. However, Tandhan Polyplast Limited has raised request for extension on 15/1/25 after a lapse of 14 working days from the date of issue of GEM contract number so and so dated 25/12/24. This amounts to the tenderer's failure to honor the contractual commitments towards an accepted contract and thus tantamount to breach of the instant contract. And if your lordship will then see para 5 on the next page. Para 5 minutes. Now, therefore, considering the failure of Tandhan Polyplast Limited to furnish requisite security deposit within the stipulated time and in accordance with the stipulations as contained in the GEM tender document and clause 21(2)(c) of the GTC of GEM tender number so and so dated 24/7/24 and GEM contract number so and so dated 25/12/24, the instant contract is hereby summarily terminated with immediate effect. Because I'm emphasizing on this, my lord, because on 26/25 they say it is terminated with immediate effect, with no reference to the previous termination email, which is issued to me on the 4th of February 25. So there can't be two termination orders coexisting.
Yes.
And also, my lords, will just bear in mind that on 4th of February they did not invoke the debarment portion of the clause. So here, in addition to the termination, they write the instant contract is hereby summarily terminated with immediate effect, besides debarment of Tandhan Polyplast Limited from participating in any future tenders of the corporation for a period of 3 years. So here again, my lords, there was no show cause notice, and the issue of debarment again is highly disproportionate, which has not been addressed by them in their affidavit. My lords will recall on the date of motion I had referred to two judgments. If I may just take your lordships back to that judgment which your lordships have authored, RMSI Private Limited. It's part of the records, my lord. If lordships will have page 8, para 12.
It was a long judgment.
Lordship.
Very long judgment. Para 8.
Para 8, my lord. Page 8, my lord. Para 12.
Yes.
My lord. So lordships have surveyed most of the case laws on the issue of debarment. So I'll just read out para 12 minutes. At this juncture, it would be necessary to refer to the pronouncements of the Supreme Court on blacklisting. In the case of Kulja Industries Limited, it has been held that a decision on blacklisting is subject to judicial review on grounds of principles of natural justice, doctrine of proportionality, arbitrariness and discrimination. The same judgment itself has dealt elaborately with the legal position on the effect and nature of blacklisting, as also the right that a petitioner possesses when such action is taken by the state or any authority in India and also in the UK and USA. Paras 20 to 25 being relevant are reproduced herein below. May I just take your lordship to para 21 of that judgment on the next page. The legal position governing blacklisting of suppliers in USA and UK is no different. In USA, instead of using the expression blacklisting, the term debarring is used by the statutes and the courts. The federal government considers suspension and debarment as a powerful tool for protecting taxpayer resources and maintaining integrity of the processes for federal acquisitions. Comprehensive guidelines are therefore issued by the government for protecting public interest from those contractors and recipients who are non-responsible, lack business integrity, or engage in dishonest or illegal conduct, or are otherwise unable to perform satisfactorily. These guidelines prescribe the following amongst other grounds for debarment. A. Conviction or of civil judgment for commission of fraud or a criminal offence in connection with attempting to obtain or performing a public or private agreement or transaction. Violation of federal or statute or state antitrust statutes, including those prescribing price fixing between competitors, allocating of customers between competitors and bid rigging, commission of embezzlement, theft, forgery, bribery, falsification or destruction of records, making false statements, tax evasion, receiving stolen property, making false claims or obstruction of justice, or commission of any other offence indicating a lack of business integrity or business honesty that seriously and directly affects our present responsibility. B. Violation of the terms of a public agreement or transaction so serious as to affect the integrity of an agency program, such as a willful failure to perform in accordance with the terms of one or more public agreements or transactions, a history of failure to perform or unsatisfactory performance of one or more public agreements or transactions, or a willful violation of a statutory or regulatory provision or requirement applicable to a public agreement or transaction. D. Any other causes, if so serious or compelling a nature that it affects your present responsibility. Well, none of these cases are attracted in my case. It's a genuine dispute. Then my lords will see para 23 at page 11.
Yeah.
And my lords, may I just also take your lordship to para 22? There are 3 other instances which may be relevant.
Yes.
A reads, the actual or potential harm or impact that results or may result from the wrongdoing, the frequency of incidents and or duration of the wrongdoing, whether there is a pattern or prior history of wrongdoing, whether the contractor has been excluded or disqualified by any agency of the federal government or has not been allowed to participate in state or local contracts or assistance agreements on the basis of conduct similar to one or more of the causes for debarment specified in this part. So none of these cases are attracted to my case. Then please see para 23. As regards the period for which the order of debarment will remain effective, the guidelines state that the same would depend on the seriousness of the case leading to such debarment. Here the debarment is for a period of entire 3 years. Then please see para 25. Suffice to say that debarment is recognized and often used as an effective method for disciplining deviant suppliers, contractors who may have committed acts of omission and commission or frauds, including misrepresentation, falsification of records, and other breaches of the regulations under which such contracts were allotted. What is notable is that the debarment is never permanent, and the period of debarment would invariably depend upon the nature of the offence committed by the erring contractor. Further, in the case of Blue Dreams, the Supreme Court has held that where the case is of an ordinary breach of contract and the explanation offered raises a bona fide dispute, blacklisting as a penalty ought not to be resorted, as debarring a person for a certain number of years tantamount to civil death, and that invoking the debarment for ordinary breach of contract where there is a bona fide dispute is not permissible. So I'll just read out the extract of this judgment. What is significant is that while setting out the guidelines prescribed in the USA, the court noticed that comprehensive guidelines for debarment were issued there for protecting public interest from those contractors and recipients who are non-responsible, lack business integrity, or engage in dishonest or illegal conduct, or are otherwise unable to perform satisfactorily. The illustrative cases set out also demonstrate that debarment as a remedy is to be invoked in cases where there is a harm or potential harm for public interest, particularly in cases where the person's conduct has demonstrated that debarment as a penalty alone will protect public interest and deter the person from repeating his actions which have a tendency to put public interest in jeopardy. In fact, it is common knowledge that in notice inviting tenders, any person blacklisted is rendered ineligible. Hence, blacklisting will not only debar the person concerned from dealing with the concerned employer, but because of the disqualification, their dealings with other entities will also is prescribed. Even in the terms and conditions of tenders in the present case, one of the conditions of eligibility is that the agency should not be blacklisted from anywhere. In other words, where the case is of an ordinary breach of contract and the explanation offered by the person concerned raises a bona fide dispute, blacklisting debarment as a penalty ought not to be resorted to. Debarring a person, albeit for a certain number of years, tantamounts to civil death inasmuch as the said person is commercially ostracized, resulting in serious consequences for the person and those who are employed by him. Too readily, invoking the debarment for ordinary cases of breach of contract where there is a bona fide dispute is not permissible. Each case no doubt would turn on the facts and circumstances thereto. The division bench, having noticed the fact that any decision to blacklist will be open to scrutiny on the anvil of doctrine of proportionality, has failed to apply the principle to the facts of the case in the correct perspective. The division bench has also failed to correctly appreciate the ratio of the decision in B.N. Joshi. There has been no inquiry by the division bench as to whether the conduct of the appellant was part of the normal vicissitudes in business and commonplace hazards in commerce, or whether the appellant had crossed the Rubicon warranting a banishment order, albeit for a temporary period, in larger public interest. And then, my lords, in the facts of this present case, lordships had held as follows at para 15.
Yes.
A perusal of the impugned order dated 27/5/2024 does not, however, make any allegation as to any fraud being committed or that there was any collusion, but the entire alleged infraction is based on the breach of the agreed terms of reference, non-fulfillment of minimum deliverables, non-remediation of deficiencies, delay in delivery, and an attempt to take advantage in the bills raised for services in advance of the payments being made. Placing the facts of the instance case against the judgments which have been quoted above, the dispute between the parties cannot be said to be or held to be fraudulent or affected public interest to such an extent as to warrant the blacklisting or debarment of the petitioner. No doubt issues have arisen which have caused a setback to the project, but in the considered view of the court, the blacklisting of the petitioners disproportionate to the infraction as alleged. And on the basis of this reasoning, my lords, lordships were pleased to interfere in this matter. So in a similar case, my lord, here the nature of the infraction is very, very minimum, a very ordinary nature of an infraction. It does not invite such a disproportionate punishment, my lord. So I would therefore pray, my lords, that lordships will deal with the debarment notice on its own merits and set it aside.
Yeah, Mr. Singh, why again such severe punishment?
Admittedly, there is natural justice has not been given to the petitioner. That's why we are silent. So far as the other part of the
question that the court put you, leaving aside anything, even if the infraction was to such an extent, that is affected, but he is entitled to at least to be given a show cause.
Yes, my lord. That I have admitted, my lord, just now.
Yes.
And regarding the remaining part of the termination letter, my lord, that remained because they have it is admittedly they have not submitted the as the amount.
See, that's fine. See, we have to distinguish between bona fide, breach of contract and a mala-fide breach of contract. Understand, if there's collusion, if there's fraud, if those kind of things. But debarment, but basically your case on, not affording hearing goes finished.
Well, we have no case for this department right now. So, my lord, the other things will remain in the termination letter, my lord. Admittedly, they have not deposited the SD amount within the 14 days.
They rendered themselves, ineligible to be to proceed with the work. That is sure. But the only thing they've come up against is against debarment, correct?
Lord.
Yes,
yes. Against the termination of contract. Then
yes.
May I just make one small prayer, my lords? I was just noticing this. If your lordship set it aside only on the question of principles of natural justice, then they may proceed on this matter afresh. The result will be the same. They will again issue a debarment order. So therefore, I would pray that lordships will set aside the debarment in itself on the merits.
Yes. And we can't take it in open court. Yes. Yes, lordship.
Oblige, my lord.
In the meantime, the interim order may kindly continue, my lords. In case, highly obliged, my lord.
64.
Continue till orders uploaded in the evening.
Highly obliged, my lord.
But insofar as, my lord, the instruction is concerned, my lord, I have received it. But he has passed the coaching course, and a certificate to that effect has also been issued to him, my lord.
But is that he is eligible now to go for selections?
No, my lord, insofar as rule is concerned, my lord, I am not aware.
Then yes,
but
MS PRC has strongly submitted that once you're a coach, you can't go for selection.
No, my lord, in the same event, I may be prevented.
So a coach for 55 kilos, you can box the 56 kilos.
No, I'm saying if I'm a coach, I will not be precluded per se, my lord, from participating as a contestant, unless, my lord, I seek to participate in the same event where I've gone as a coach.
That's correct.
Lordship, Lordship, the team of when he is a coach, he is a part of the team officials.
No, in the same event,
and,
I cannot.
No, Lordship, it is the technicality is there, Lordship. When he is already qualified as a coach, he is certified to be a coach, and he has become when he is a certified to be a coach, he has become a part of the team official delegations, Lordship.
No.
That's why I say, my lord, if in the same event.
Coach, see, one thing, coach won't be the same coach for all events.
Absolutely.
Suppose today Mr. Thapa is coaching badminton team, right? Tomorrow, then he's not. When there's another event, when the team is
I'm not going.
They put you as a coach. So in that event, will he be eligible to apply to be part of your team where you're the coach?
Lordship,
Well, that's what he's saying.
Yeah,
So
yeah.
suppose I might be a coach
no,
in that
Lordship.
event where I'm coaching. I won't.
I will be
Yeah.
precluded
But
from.
you suppose you're coaching, you're taking another team. Can you make him part of the team?
Lordship, the second one, Lordship, this boxing federation, Lordship.
Okay, where does it say that a coach is barred from
I don't
putting
think
up
so,
his
but there's
candidature?
any rule to that effect.
Boxing federation, Lordship.
Yes, IBA.
Yes.
No, this is IBA.
No, no.
BFI.
BFI.
Boxing Federation, is small one.
Yes,
This one.
small one. Yes.
Yes.
Here, part B. I have tagged Lordship.
Okay. Very interesting case. Part B.
Part B.
Rules of no, is it?
Yes. Point number
Yes.
9.
Yes.
Point
9.
number 9. Officials means the supervisors, RJs. RJs means referees and judges. Technical officials, coaches, managers, team delegations, timekeepers, doctors. So they are all part of the officials, Lordship. How they
I
can
don't
be
deny
a
that, my lord.
Lordship? How can they be a? How can they participate in the ring?
No,
Lordship?
no. See, you try to get his argument. What he's saying, fine. Suppose I'm official in a certain event as a coach. I cannot offer my candidature to take part as a participant. Okay. But suppose I put myself candidature for other events where he's not a coach, he's not part of the official. Can he do that or not? That's only.
Yes.
We already dictated the order. That's
Right,
only
Lord.
last part remains.
Even I've gone through this rule, my lord. There's nothing as such which prevents me from
Get
participating.
some instance. Get a real instance has happened. There is a coach. He's passed his coaching, but he's gone and taken part. In another event where he's not a coach. Get that, then we'll close the matter. And you find that the coach he's a coach, can't take part anymore.
There's no rule, my lord, as such which prevents me
You
from.
get a field instance. You get from the records.
I'll try, my lord.
your
Because
petitioner,
he
he'll
being
know.
a contestant, my lord, it is
No,
difficult.
he'll know. Whether
Lordship, I'll just draw one more thing from IBA Technical and Competition, page number 8.
IBA.
IBA, page number 8, Lordship.
Yes. Team delegation.
Team delegation, then team officials.
Yes.
Means the member of
Except
that.
the boxers.
Except the boxers.
He's saying different. He says, suppose I'm not part of team delegation, I want to put my candidate as a boxer only. That's all. Whether he can do that.
Okay, I'll find out on that.
And today, MSP Prasaji has submitted that a coach being part of being an official of a team in any event is barred by the rules and regulations of the Boxing Federation to compete. Stop. Mr. S. Thapa, however, submitted that it might be an instance where the writ petitioner is not the coach but seeks to take part as a boxer in an event where he's not an official. Stop. He prays for both the parties pray for and allowed further 1 week's time to finally come up with specific instructions or instances. Then they'll become at least a judge. Interesting. But orders already dictated, only the last part. Right. We'll keep this or you take it back?
No, Lordship.